Welcome back to Canadian Justice, where we're discussing recent amendments to the Canadian Competition Act dealing with greenwashing. And we're joined by Grant Bishop. Now, Grant, one of the big amendments to to the Competition Act designed to stop greenwashing does something unusual. It creates a reverse onus on businesses to prove that their claims about their environmental initiatives, that those claims are true. And if the claims are challenged, the business needs to demonstrate based on, quote, adequate and proper substantiation in accordance with internationally recognized methodology that their claims are true. So I have kind of two questions coming out of these amendments. First, is a reverse onus, this type of reverse onus they've created here, is that a departure from the normal way that misleading advertising law works? And second, what does internationally recognized methodology actually mean?
So maybe just I'll take the first part, excuse me, the second part first. I mean, I don't know, and I think there's great concern throughout the bar about what internationally recognized methodology means. There's no guidance in the Act for what it would mean in terms of factors, and this is a new term in the Act that has not been previously litigated or considered by courts. And I think that goes to the vagueness question and the overbreadth question of that provision, which we can come to. But on the reverse onus, there are reverse onuses in the Act, and specifically for misleading advertising. I mentioned the pre-existing adequate and proper testing requirement that has been fairly extensively litigated and constitutionally considered. There was a challenge brought, I was part of it in a former life, to the constitutionality, to the freedom of expression questions around that adequate and proper testing requirement. It does impose a reverse onus on making a claim, but that claim is about the truth of the claim and the objective test that a claimant must do ahead of making it to have a valid basis for putting that claim into the market. The concern here is about putting uncertain claims into the market. What's being added with the substantiation requirement with the internationally recognized methodology prong is different, though. It's not about there being an objective basis. It's about a third party, nebulously defined, blessing how you have come to that substantiation. And a central overbreadth concern here is that innovation is going to outpace the bureaucratic delineation of those bounds, notwithstanding that what fits as a internationally recognized methodology is uncertain. One cannot be certain whether one is inside or outside of an internationally recognized methodology,
Now,
at least as it's stated in the Act.
one of the concerns that some people have raised, I think you've also raised this just now when you talk about innovation, is that because innovation might outpace international standards. There's a particular concern among some that this new law will be particularly damaging for clean tech innovation, which ultimately is harmful for the entire industry and harmful for actually developing new environmentally beneficial technologies. What can you tell us about that?
Yes, and again, I submit that innovation will continually outpace bureaucracy. And many supporters of this law have pointed to methodologies, standards that have proliferated in recent years to verify the environmental performance of different types of activities. But that's sort of aside the important edge case where a new innovator comes up with something for which a methodology doesn't yet exist, whether that's solvent in oil sands extraction or solid mineralization of carbon or some other yet uninnovated form of improving environmental performance. That any innovator has to wait for there to be an international consensus around an appropriate methodology so that they can make a representation to the public about this new thing actually works contrary to competition, contrary to the public interest in learning about new advances. This is exactly why the freedom of expression needs to diligently protect these sorts of nominally perhaps commercial, but truly
Mhm.
informational representations to the
Right.
public, and
Yeah,
why
freedom
putting
of
a third
expression
party.
being a right that we have constitutionally guaranteed that this law could might be infringing on. We've got to go to break now, but we'll be right back.